I will now call the first case on the docket, State v. Valenciana, case number 126839. And counsel, when you're ready, you may approach.
Again, may it please the court, Kristen Patty, counsel for the appellant, Saul Valenciana. To get the sixth issue out of the way, I realize that that's a really strange place to start. But that's the Betker-Smith criminal threat claim. Certainly, that's the least of Mr. Valenciana's problems in this appeal. It may be obvious from the way that I've briefed it that I'm probably going to raise cumulative error in any jury trial appeal if I can come up with two errors. But in this case, I really see the instructional error in the first claim and the prosecutorial error in the third claim as being causal. There would be a causal connection between the two. And then a little bit of a lesser degree, but still, the refusal to instruct on voluntary manslaughter in the second claim and the use of heat of passion by the prosecutors in closing argument and the denial of a motion for mistrial in the fourth claim as also being connected. Ms. Kuhn is, and I spoke yesterday and I told her I expected that probably a lot of my 12 minutes up here will end up being about the first and third issues. What we're talking about as far as the first issue, the definition of premeditation. The district court, the trial court gave an expanded definition of premeditation in this case. And Mr. Valenciana argues that first, it was not legally appropriate. Second, was not factually appropriate. And third, that error was not harmless. Factually, what we're talking about is maybe 3 minutes. And I say that because we know from the co-defendant, Taya Turner, when she talks about how, that the cutting of Mr. Boone's throat in the driveway at the house on North Pershing, the momentary, I would hate to use the word struggle because we use it in a different context with respect to this argument, but the initial disruption there, and that by the time they got to the intersection of Central and Oliver in Wichita, Mr. Boone had stopped breathing, and that's where they changed drivers. She had been in the driver's seat. Mr. Valenciana had been in the rear passenger seat. That takes about 3 minutes to drive. I think that a reasonable inference from the evidence is that at that point, if Mr. Valenciana wasn't dead, he was certainly beyond the point of any meaningful medical intervention. There's certainly, there is.
I just want to interrupt because I don't want to lose this in my head.
Okay.
Is the 3 minutes you're referencing in the record, or are you inferring that from the locations?
I'm inferring that from the location. I think
there was no testimony or evidence about 3 minutes.
No, and most of it is, to be honest, it's geography that's very familiar to me. I drive through that intersection all the time. I think if they had made it farther, say to the intersection of Douglas and Oliver, she would have used those cross streets. So that's why I say that, and you can take judicial notice of maps. Trying to figure out where I was. So again, the trial court gave an expanded definition of premeditation. And And here there was not, first of all, it wasn't legally appropriate because the trial court did not follow what you said in Stanley, all the things that a trial court must give if they do give something that is beyond the definition in PIC. A trial court is never wrong. If it just sticks with the definition of PIC that's provided in PIC. But certainly sometimes when the certain circumstances warrant it, this court has approved an expanded definition.
Okay, so let's assume for a minute that we assume error. What about harmlessness?
And this is where I see that the causal connection, because the trial court said, okay, you can use this expanded definition of premeditation, then the prosecutors went and they argued in closing argument. They told the jury that it could consider dumping the body, that it could consider cleaning up afterwards. And certainly, defense attorneys know that there are bad facts in cases that are just going to come in because it's part of telling the story. But again, it's whether you believe a reasonable inference from the evidence that Mr. Valenciana was either dead or past the point of medical intervention by the time they changed drivers, somewhere south of the intersection of Central and Oliver, however long that took. It certainly didn't go as far as dumping the body in Northwest Sumner County or cleaning up afterwards. That's all post-meditation. And again, it's bad facts, but the prosecutor told the jury in closing argument that they could consider that. There was not, and I'm sure that Ms. Kuhn will argue, at least as the way it was briefed, the way Mr. Gillette briefed it was, we don't know how long Mr. Valenciana may have been planning the events that ended up taking place that night. He uses the word may several times in that section of the brief. But really what we know is the things occurred within a very few minutes in the driveway at the house of North Pershing. There certainly was not, as far as, and this begins to go to the factually appropriate part, there wasn't a protracted struggle that there has been, say, in Stafford. There wasn't a substantial period of time. In Zonker, the defendant had an altercation outside of the restaurant, went back in, and then came back out to end up shooting the owner. Hollins, there was a 25-minute window. We don't have that here. We have, and again, yes, this is an assumption on my part, from what a reasonable inference, I think that's from the record. We have maybe, 3 minutes that we're talking about.
Why isn't that enough?
Because there was also an instruction for intentional second degree. And obviously, which obviously the jury rejected.
I'm sorry, maybe I should clarify.
Okay.
I'm talking about the error. Why is the instruction erroneous? I understand that you have an issue with the Bernhardt language, and I thought that you were tying that to this 3 minute of a quarrel or possibly a struggle.
Well, I have to argue, right, that what the instruction that was given was not legally appropriate. And then
How is it not appropriate to give an instruction on premeditation?
the expanded definition of premeditation.
But why wouldn't, I guess that's, how do we assess if it's factually appropriate? What's the legal argument, I guess?
That it did not contain the additional language that's in a syllabus paragraph in this court's opinion from Stanley, that the trial court must also instruct the jury with specific language.
And what was not included from Stanley? Just the clause that is sufficient to allow the actor to change his or her mind?
That and more than mere impulse, aim, purpose, or objective. It's like, I guess, basically, if there are three things that Stanley requires, the trial court used the middle one and not the first and the third.
Okay.
So that's why it's not legally appropriate. It was because it was not what this court has said is a complete and accurate statement of Kansas law. And then I have to argue that it wasn't factually appropriate, and then we start to get kind of blurry. The defense also requested an instruction on voluntary manslaughter because, and I've used the language that Mr. White, the defense counsel, how explained to the judge why he thought that was appropriate. There was a discussion in the car where they were trying to get Mr. Boone to admit that he had done something wrong by basically engaging in sexually explicit conduct of with a minor. By recording him having sex, and he was in his late 30s at the time, and Ms. Turner was 17, a minor. And then not just recording it, but he disseminated that to someone else. And Mr. Boone repeatedly refused to admit that he'd done anything wrong. And when you think about sometimes when you're having an argument with somebody, you're angry, and then when the person you're angry with doesn't say, I'm sorry, you're right, it can make you angrier. We also had a level of intoxication from drugs and alcohol that had been consumed earlier in that day. I'm nearly out of time. If there are no further questions, I'll back up for rebuttal. Thank you.
Any questions, colleagues? Thank you, Miss Patty. Ms. Kuhn, and thank you for filling in today.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. As you acknowledged, I am filling in, so I apologize if I may not be as well versed in the case, and I may not be able to answer your questions, but I will attempt. So first, the first issue regarding the premeditation instruction. It is our position that the district court's instructional language clarifying the meaning of premeditation was appropriate, both legally and factually.
And I know you can't, but why was there even a request to clarify? It just seems to me the standard PIC language fit premeditation with the facts here. I don't understand what the motivation was to go further than what PIC requires.
I can't speak fully to the motivation because of the limited time I've had with the record, but
can you figure it out from? Can you figure it out from the facts? I can't. I mean,
my understanding from the briefing and what I was able to read is I believe there was some concern due to the temporal intricacies that could confuse the jurors regarding whether there was premeditation here or not because of the facts of the case. So that's my understanding and the thought behind giving the Bernhardt type instruction. And what's missing here, so as we know, the use of pattern instructions is strongly recommended, but this court has also said that judges may add language to a pattern instruction where if the facts warrant modifications or additions, the court should not hesitate to make such modification. So in Bernhardt, this court approved adding language to the premeditation instruction when factually warranted. Now here I will acknowledge that the district court gave a Bernhardt type instruction, but it was missing 2 sentences. But it's our position that while those 2 clauses were not including, that does not create error here, because the instruction was still legally appropriate, because the language in this instruction was consistent with that recommended and approved by this court. Every part of the instruction came from either the PIC, controlling case law, or the parties' agreement. So the complete thrust of the language suggested by this court in Stanley was contained in this instruction. First, that premeditation being more than a mere impulse was captured by language from the PIC and precedents of Hilliard and Bernhardt. Then the period of conscious reflection was incorporated verbatim from the Stanley case. And then additionally, the time to change one's mind was encompassed by the language from Hilliard, Stanley, and Moore, employed that required a thought process to occur prior to engaging in the homicidal conduct and before the final act of the killing, which the court reinforced for this jury, and it was properly for them to decide. Next, we argue that this instruction was factually warranted because I stated the question was whether jurors could be confused over the temporal intricacies embedded in the legal concept of premeditation. And there was a temporal intricacy here and a dispute that warranted this Barnhart type instruction. The facts here were ripe for confusion regarding the temporal aspect here of premeditation. The defendant could have performed it days in advance when he and his girlfriend were discussing the previous sex tape that Mr. Boone had created of the co-defendant. He may have formed it during the confrontation in the car before slashing the victim's neck, or he could have formed it sometime after the slash as Boone fought to live, because there was evidence both from the co-defendant and the autopsy that Mr. Boone also suffered additional stab wounds. I believe the evidence states 13. So based on all of that, it is our position that this instruction was both legally and factually appropriate. Now, if the omission of the 2 clauses, the language of more than a mere impulse, aim, purpose, or objective, and sufficient to allow the actor to change his or her mind and abandon his or her previous impulsive intentions, if leaving those 2 sentences out was error, we would argue that that was harmless. There was no question in this case about the defendant's identity as the killer. The evidence of defendant's premeditated and intentional killing of the victim was so overwhelming that any reasonable jury would have found him guilty regardless of any specific language employed in a Bernhardt type instruction. Additionally, instruction regarding the language regarding impulsive intentions or more than a mere impulse is essentially contained within that first paragraph of the instruction, and that comes straight from the PIC, where the instruction says, although there's no specific time period required for premeditation, the concept of premeditation requires more than the instantaneous intentional act of taking another's life. So our position is the instruction contained all of the necessary direction to the jury, and any omission of those 2 clauses was harmless. moving to the prosecutorial error claim, the prosecutor here, my understanding of the claim is that the prosecutor erred by misstating the law on premeditation. And I believe there was some argument in the briefs about the prosecutors trying to backdate premeditation. It is our position that they were not trying to backdate premeditation. They were arguing how certain circumstances lent support for their theory that the defendant premeditated his murder of Boone. And those circumstances included everything from putting a knife to Mr. Boone's throat to repeatedly stabbing Mr. Boone after slashing his throat. The many different acts that defendant could have taken after he started inflicting sharp force injuries upon Boone, the opportunity to get him help, knowing what he had done, but continuing to drive, continuing to leave the city, and then acts after Boone was likely deceased, consistent with defendant following through on a premeditated plan to kill Boone. Those arguments were all proper, and there was no misstatement of fact and no misstatement of law here. Additionally, if this court were to find that any of the prosecutor's argument were error, it's our position that they were harmless. There's no reasonable possibility that any of those statements contributed to the verdict. Defendant does not dispute the reality that each of the complained arguments had factual support, nor does he dispute that the conduct after a killing and or dealing lethal blows after a deceased was felled and rendered helpless can support premeditation. Additionally, the jurors received the proper instructions here that arguments of counsel were intended to help them understand, but were not evidence. And it's our position here that it was the weight of the evidence supporting premeditation that led to defendant's conviction and not any comments made by the prosecutor. If there are not any questions regarding any of the other issues, I would submit them on the briefs, but I'm open to any questions that I could attempt to answer.
Colleagues, any questions? Ms. Kuhn. Thank you very much for your
Thank you.
arguments.
And we would ask that this court affirm the district court and affirm defendant's convictions.
Ms. Patty, you reserve 3 minutes.
I realize that telling you that there are some things we just don't do is not really a legal argument. Premeditation, the idea that there has to be a thought that happens beforehand and some period of time for conscious reflection, even if brief, is, and I didn't know how to phrase it. I couldn't find a citation for it, but to me, it just seems to be a bedrock element implicit in the concept of ordered liberty that we use sometimes in other contexts. I think this case crosses the line that Justice Johnson spoke of in his dissent in Bernhardt. And this wasn't a type of case like Bernhardt where, if you remember, Mr. Bernhardt kicked Ms. Cosner multiple times and in the head, then put her in the back seat of the car, was driving, she was gasping, she was bothering him. So then he took her out, put her in the trunk, and then later dumped her beside the road. This isn't that sort of case where Mr. Bernhardt might have gotten Ms. Cosner help. Again, it's what you believe from the evidence, Ms. Turner's testimony about what happened from the driveway on Pershing to when they changed drivers just past Central and Oliver, and whether you believe that Mr. Boone was beyond reasonable medical help at that point. I think it is a reasonable inference that he was. And if there were no further questions, Mr. Valenciana would ask that you reverse his convictions and remand this case for a new trial.
Any questions, colleagues? Thank you very much for your arguments this morning. I'm in this morning. This afternoon, this matter will be taken under advisement.